Great. Hi, everyone. This is Kim Bradell with Remkes Consulting Group. Remkes has been a longtime sponsor of the ABA NCBP, and we're honored to join you here today online. Although I think I speak for the majority when I say that we can't wait to see you in person. One of these days, right? So today I have the privilege of introducing the opening plenary session, Shaping the Future We Need in the Legal Profession. We're heading back to our offices, bar associations, and the courts, but what does that mean? Some would like to go back to the way things were before the pandemic, but real leaders are those that are shaping a new future, a future that uses what worked during the months of lockdown to create a new system for the legal profession, increasing access to justice, opening up more opportunities for engagement, and helping lawyers practice better. This is your opportunity to become a bar leader who shapes a better future for your members, for those in the judicial system, and for your community. In keeping with the spirit of these concepts, Remkes has used the last 18 months to reflect on who we are as a company and what actions we can take to enable us to better serve our clients. During this time, we have of course focused on the safety and well-being of our employees and clients, but beyond that, we've taken steps to strengthen our company both internally and externally. My colleague Don Bopp and I are going to talk a little bit more about that during the partner session this afternoon, but a few overarching best practices that I've observed within our company are embrace change and recognize that it leads to growth. Keep an open mind and always look for ways to improve. When developing new ideas and plans, make sure to involve people from different backgrounds and with varying levels of experience. The wide variety of perspective will strengthen your end product. And finally, think about what it really means to connect and make a difference. What actions can you take to foster that within your groups? All of that being said, I'm happy to turn the floor over to our speakers for this session, which will be moderated by Jane Reardon out of Chicago. She's the Executive Director of the Illinois Supreme Court Commission on Professionalism. Jane, the screen's yours.
Thank you, Kim, and welcome everyone. We survived Lollapalooza in person in Chicago. Let's see what the aftermath brings. I'm delighted to be moderating the opening plenary session, Shaping the Future We Need in the Legal Profession. I'm a big fan of the NCBP programming, and the name of the program is really apt because you, bar presidents, have the power and the responsibility to shape the future of the legal profession. You've reached the position you hold because you are recognized as a lawyer with wisdom and judgment. You have the confidence of lawyers and judges in your respective jurisdictions. The hopes of our profession are really pinned on your shoulders. It has become apparent over the last decade or more that the legal and judicial systems designed 100 or more years ago are just not working well. The pandemic has opened our eyes to yawning gaps in our profession and its services. We pivoted, we adapted, and now plans are being made to return to working in offices. Yet just in the last week, we've seen that some of these plans may be readjusted due to yet another variant. It is very clear we will not be going back to the old days pre-pandemic, which is good because the old days just weren't good enough. So you have an exciting challenge as a leader at this time. This bar year promises to be more dynamic than last year. You'll need to know what the changes are, what your members and the community need, and you will need to be monitoring this in real time as changes are highly likely. However, as Kim said, you have at your disposal nearly a year and a half of data around ways we've adapted during the pandemic. You have the opportunity to shape a new future that uses what worked during months of lockdowns to create new systems for the legal profession, increasing access to justice, opening up more opportunities for engagement, and helping lawyers practice better. This is your opportunity to become a bold leader who shapes a better future. And this program is designed to give you tools to use as you shape the services your bar can provide to members and the public in our common goal of increasing access to justice and upholding the rule of law. So I'm going to be so pleased to introduce you to the speakers now. To talk about the future of the profession, we have Bill Bay and Laura Farber. Bill and Laura are the co-chairs of the ABA Practice Forward Task Force Group. This group conducted the largest national survey of lawyers who shared candid and sometimes heartbreaking stories about what it has been like to practice during the pandemic and their expectations of post-pandemic law practice. Next, we were going to have Justice Adrienne Nelson of Oregon to talk about what the judicial system is going to look like moving forward. Unfortunately, she had an emergency that prevents her from being here today, so I, along with the other panelists, are going to handle the topic of the future of the courts and lessons learned in the pandemic. Finally, Connecticut Bar Association immediate past president Amy Lynn Meyerson will tell us how Connecticut is using the Practice Forward model to provide services to their members. First up will be Bill Bay and Laura Farber. Bill is a partner in the St. Louis office of Thompson Coburn. He's past chair of the ABA House of Delegates and of the ABA section of litigation, as well as a past member of the ABA Board of Governors. Bill is also a member of the American Law Institute and has been selected as chair of a number of statewide commissions examining critical issues in the practice of law in Missouri. Laura Farber is a partner in the Pasadena, California office of Hahn & Hahn, where she's a member of the firm's litigation and employment practice groups. For the past 5 years, she's been a California delegate to the ABA House of Delegates and has held numerous leadership positions within the ABA, including the Board of Governors, chair of the Young Lawyers Division, and chair of the Solo and Small Firm Division. With these credentials and breadth of experience, you can see why Bill and Laura were tapped by ABA Presidents Judy Perry Martinez and Trish Rifo to be co-chairs of the coordinating group on Practice Forward. Bill and Laura, tell us what the ABA is doing to help lawyers move forward post-pandemic.
Okay, great. Jane, thank you very much. Thank you on behalf of Laura and I. You're going to hear a lot from us, but we're going to try to pack it in a very quick few minutes. And thanks for the opportunity to participate in this virtual annual meeting, and especially for the leadership of NCBP. I mean, you guys are really on the front lines of these challenging times, and leadership is now needed more than ever. Let me just start out with a couple of quick thank yous to the terrific bar services staff. I never like to not mention them. They're so good at what they do. And a special thanks to your leadership, President Aurora Austriaco. And the NCBP is, I think, a great place to find committed leaders, you know, people like Aurora, Nate Alder, Jennifer Parent, many others. Thanks for all you guys do. As Jane said, the last 17 months have been challenging to our profession, our courts, our members, our communities. We know you guys have been on the front lines. We've been there with you. Today, we want to talk about some important data and information the ABA has gathered through what we call ABA Practice Forward, and to also talk about an approach we've taken and how you can utilize it. So whether it's really reentry and remote workforce issues, DEI issues, well-being, financial recovery, ABA Practice Forward has resources and tools we hope you will utilize as you serve our members. So let's kind of jump right in. Jane alluded to this. What is Practice Forward? It's a great team of attorneys and staff with one focus, serving members at their point of need during the pandemic and helping them to adjust to a new normal. The group was created, as Jane said, last May by the executive committee of the board of the ABA at the behest of then President Martinez and current President Rifo. The goal really was to take quick action to meet the challenges facing our profession you'd expect from the ABA. So to begin a big task, where do we start? We ask people, we listen to people. What are the challenges? What are the concerns? What are you seeing and experiencing? And we sent really a survey, almost 5,000 recipients throughout the ABA, and found out what's there. And we got a pretty good representative sample. We generated a 75-page report. I think there's going to be a link in the messages. I think you will really find it's well worth the read. There's lots of data, lots of findings, lots of recommendations. We're going to start, though, today by Laura giving us kind of a tour of the survey findings from 20,000 feet. Laura, go ahead, and we'll go to the next slide and go ahead and start with the big picture.
All right, thanks so much. It's been a pleasure to work with Bill, who's phenomenal co-chair, and thank you for having us. Some big picture areas of concern, professional and personal, which I don't think are going to come completely as a shock to most folks. First of all, more than half of all lawyers work from home 100% of the time, which did not, I mean, I had no idea that that was the case. Clearly, those numbers have changed and will possibly continue to change over the course of what we're experiencing. But lawyers have been overwhelmed by everything that they've had to do, and they've been worried about employer support, workplace resources, being recognized for what you're doing, especially when you're working remotely, because people don't see you in the traditional way that they've seen you, and of course, job security. None of that, it should come as too much of a surprise, but worrying about things like having access to clients and how are you going to develop business in a different format or a different way or a different approach. Those have all been concerns. Billable hour requirements have not been reduced, and there have been much higher levels of stress because of how you're managing work and home, especially when you have young children. And I'll talk about that later for parents, especially for women. It's been very, very challenging. And there's been higher levels of disengagement from work because of the adjustment to working in different platforms and working remotely. Greater thought about whether it's worth it, especially for women. You may have seen a lot of statistics, not just in the legal profession, but generally about women leaving the profession or questioning whether they want to stay or thinking about part-time or some other alternatives. And the greatest impact has been on lawyers with young children, especially women, especially when these young children have had to work or had to go to school online. And you also have had women bearing the brunt of taking care of the children and managing those parameters between work and taking care of the kids, which can be especially challenging. There's been positivity about having sufficient revenue to meet business goals, believe it or not, because people have still needed the legal advice. Question about need for office space. And we're going to see those trends if we haven't already, especially in the commercial real estate market, in terms of firms contracting or deciding they don't need as much space, or lawyers sharing offices. And it definitely raises questions about culture and about how we're going to look. What is our office going to look like? How are we going to do things together? How are we going to work as a group and a unit when we're not physically together? How are we going to engage? Can you go to the next slide? And the data that stand out, I've been sort of referring to some of this, the tremendous pressures that have fallen on women and children. Women clearly want more supportive and engaged employers. They're looking for policies on sick and family leave and providing subsidies for childcare and tutoring or family care, or care for seniors or parents and others that may need it. Need for effective diversity, equity, and inclusion strategies. For example, this was really surprising. In my view, there's been more than one pandemic. I think not only did we have the pandemic relating to COVID-19, but also racial justice, social justice. And so 47% of lawyers of color have felt stress at work at least some time on account of race and ethnicity. I mean, that is a large number. And 19% of them have felt stress very often or almost all the time. And then you've got the double bind, the intersectionality of race and gender. So that was really, really interesting, not necessarily surprising, but very interesting. And women and lawyers of color are much less optimistic about the legal profession as a whole. And the data beg the question, are we positioned, is the legal profession positioned long-term to be as diverse and inclusive as society and as it should be? Next slide. Conversations about race and ethnicity have been taking place in a way that is very not surprising in our view, but compared to a year ago, 82% reported having conversations with colleagues about racial justice much more often. And 37% reported that those conversations were easier or much easier, and 51% reported that it's about the same. It didn't really change in terms of pre-pandemic and during pandemic. But there were no strong differences between white lawyers and lawyers of color, between those in leadership positions or other members. So this is an area that we thought was very important to share and that we should all keep our eye on. Next slide. Bill, you're going to talk about this one.
Yes, anticipating the future. I know everybody wants to know what's the future like. Shoot, I think about that every day, but there's a lot we don't know about the future, but the survey really talks about certain trends that we are fairly certain about. Remote working is here to stay in some form. People like it. No surprise to you guys. Flexibility work trends are growing and here to stay. People like that. We're going to continue to see that. The profession has discovered and is starting to embrace lawyer well-being, to which many of us would say about time. Workplace culture more important than ever. This is really a critical item, and diverse and inclusive workplaces are more important than ever. And on both of these has to be more than talk. Accountability counts, and tools that measure it are crucial. And you'll see the survey report talks about measuring and reporting and accountability. That's so critical. And the survey report, I think, really presents an opportunity for you guys to utilize this data and solutions, be part of the change we need to make the moment. So we have some resources in the report. Laura, tell us about some of those.
Sure. Well, there was no one type of member service that most ABA members agreed would be useful, but certain services had greater appeal for women and for lawyers of color and younger lawyers. So we think you should be paying attention to these because these could be very useful. Guidance about enhancing mental health and well-being, clearly important. Guidance about ways to implement effective DEI programs, better resources for working parents. I've alluded to the issues relating to that. Robust mentoring and sponsorship programs, and providing opportunities to participate in pro bono. Those stood out, and those are clearly things that bar associations should and could be doing. Next slide. And planning for member services with a focus on young lawyers. What do they want? They want guidance about business development, because that would have been something they wanted pre-pandemic, but now during the pandemic and hopefully post-pandemic as we emerge, they still need that guidance on different platforms. Guidance about staffing models, networking events, even if they're virtual. How are we going to make them happen, and how to make them useful, and how to participate in a way that's effective, connecting them to affinity groups, and the data point to the strategy of targeting programs to various member groups. So you want to try to focus on these various member groups as you plan your programming. Next slide. Bill, tell us about some of the best practices for employers.
So best practices, guys, there's 20 pages in the report about practical best practices. We're giving you this, the overview of the 17, even that's an awful lot here. But what we did is tried to focus, what are the best practices we can use in our workplaces? There's 10 of those, and our own careers, there's 7 of those. They're discussed in the report in the last 20 pages of it. And I encourage you to read it carefully. They're on the next 3 slides. You're seeing the first one, and in a moment we can go to number 2. These are practical things every employer can do to make their workplace ready for the challenges of a post-pandemic world. And we go to the next one here if you can. There are also practical things every lawyer can do. 17 best practices, I think, permit you as leaders of your bar to provide real solutions and guidance at a time when our members need it. And the best part of it is we're not just talking about it. The survey report gives members real data and these practical items. And we go to the next slide, which is about employees. And I think the key thing we thought as a bar association is we're trying to empower our members to be effective voices where they work and are at home. And I think it's part of a group that fashions solutions for their employment setting. It's also a unique time, I think, where members can rediscover how valuable it is to be part of a bar association that meets them at their point of need. And I think that's a big message that we in the ABA think is important, and I suspect each one of you think it's important. What does that mean for us in the organized bar? I think it means change is here in how we do everything about a bar association. More change is coming. Our members know it. They're going to demand it. And the survey tells us that we have to adapt and be very dynamic about moving forward. The good news is we can really do that. Laura, other things to add about some of the recommendations?
Well, I particularly think the one about self-care is huge. And I think we should all be focusing on that because lawyers are notorious for taking care of everyone around them except for themselves. And clearly that's become an issue, especially when it comes to well-being and mental health. And so that is something that we'll share a little more about in a moment. But I think that's a focus area that we should be, as bar associations, paying close attention to and figuring out ways we can serve our members in that regard.
Well, tell us a bit, Laura, about what we've done with the survey results. We did a survey. It's great. The report is great, but we went beyond that. Tell us about that.
Can you go to the next slide? Well, what we've done in the ABA House of Delegates, which many of your participants know about, is that we've proposed policy resolutions, 2 of which were passed at the mid-year meeting. The first was on child and family care, And that one actually, believe it or not, was also based on support from the US Chamber of Commerce that is lobbying Congress to make sure there's funding for this, which is really crucial to getting people back into the workforce and getting our economy going. And then on wellness, that is one of the only times I have heard a unanimous, meaning everyone in the House supported this resolution. And that is once again, providing best practices and resources. And we've got the COLAP, Commission on Lawyer Assistance Programs, and many of your bar associations know about that. And you've got the local COLAP groups. Those are huge, huge and helpful. We have 2 resolutions that are coming up here at our annual meeting for the ABA, one on reentry and providing practical and best practices resources, and the other on how has reentry or potentially has reentry going to impact issues of diversity, equity, and inclusion. And once again, best practices and resources that can be used for that. And then stay tuned for ABA mid-year next year that we are planning on co-sponsoring a resolution on ethics, which deals with the definition of attorney competence in the comments, including mental health and well-being in those definitions, which California, Virginia, and Vermont currently do. So that's going to be forthcoming, and possibly some other resolutions, but that's what has been done. And now it's a question of implementing those policies once they are adopted. Next slide. Bill.
So what can you expect to see next? I think you guys know it. It's a focus on reentry, opening offices, and what's the new normal? What is the new normal? And as we're seeing in the courts, it changes day to day. So the next slide is what can you expect to see? I think we can go to the next one there. You're going to see a lot more resources about how is practice changing? Is virtual litigation, motions, depositions, trials, appearances, are they here to stay? Reentry issues as offices reopen. Can you require people to be vaccinated? Can you require people to come in? The hybrid and remote work issues, the wellness issues, the culture issues Laura's talked about. How are we going to mentor people in different settings when they're mostly from home? Are we going to deal with hoteling? Diversity, equity, inclusion issues? What needs to be done now, and how can we measure progress? So I think one of the key things I've kind of learned and we've talked about is that, and just as a close, one of the keys to the future is how we're going to approach the new normal. And let me talk about 3 things real quick. The keys, I think, are listening, content, and delivery. And what do I mean? Number 1 challenge for leadership is always listening, focusing on what members want. Make sure that we listen to what people say who are outside of leadership, outside of the people who are active, because sometimes we want to do what we think they need as opposed to what people really say they need. Number 2 is content that you have as your currency. It has to be relevant, timely, and dynamic. And by dynamic, I mean changing because the profession changes. And then 3rd is about delivery. I mean, we've talked about a website. It's great to have a website that's easy to use. It's great to have a website that people will come to, but not everybody will come. You guys know this. You got to meet lawyers where they're at with email, Twitter, Instagram, LinkedIn, and Facebook. So what we want to do is hear from you in the future. Tell us about what you're seeing. It's a big effort for the entire profession. We want to be part of the solution that you have for your members, and want to be sure we're hearing from you. So please call us. Laura, last word?
Yeah, I think that we are seeing a complete change, and that is the key here, is change and be open to change, be flexible. And we're seeing, and I predict that we're going to see more of that in the way firms are expecting lawyers to work, as we see hybrids, as we see the approach to use of technology and those platforms. It's just going to be change. And as long as we're willing and open to embrace it, I think we're all going to be fine. Whether we're bar association leaders that are trying to help other firms or practice settings or lawyers succeed, or whether we're trying to provide the resources, everything that we do as bar associations, I think we have to keep that in the back of our minds. Anyway, this has been wonderful, and thank you for the opportunity, and we look forward to answering questions later on in the program.
Thanks, Laura and Bill. And if you could just say, and I assume it's going to be in the resources, that website is fantastic. What is the URL? Because it's not on this last slide. Is it ambar.org?
Yeah, it's on the front page. We occupy beachfront property in the ABA.
All right.
Page, unobstructed views, right there on the front page every time it's Practice Forward. And we'll put a link in here and make sure it gets on there.
All right, and you should all check it out. The resources there are unbelievably helpful. So now we're going to turn to the issue of courts that Bill alluded to, because during the pandemic, as lawyers pivoted, courts needed to pivot, and that's a much larger ship to turn. And so we're at the point now trying to review what worked, what didn't. And just as in the delivery of legal services, technology became key. Two mantras I heard reiterated by Supreme Court justices in Illinois here and throughout the country were these. The pandemic was not the disruption the courts wanted, but it was the disruption we needed to embrace new ways of operating and be more transparent and user-friendly. And they did that in a big way. The second quote I've heard from, and you probably have as well, Richard Susskind for a number of years, and that is this: we have to realize that courts are not a place, but a service. We're delivering a service, and it cannot be dependent on physicality. So the changes that came about last March were not uniform, of course, because jurisdictions were at different places in adopting technology and digitizing, e-filing, et cetera. Also, different parts of the justice system experienced an increased workload, for example, criminal, child protection, orders of protection, domestic, where others did not. As the economy collapsed during the lockdowns, there was decreased activities in certain areas, such as mergers and acquisitions, what have you. Now, coming out of the pandemic, we're expecting to see an increase in courts' workload in certain areas. You've all been reading about the moratoriums on evictions that are being lifted or soon will be lifted in jurisdictions across the nation, and the anticipated boom in foreclosures and other landlord-tenant issues. Courts across the nation are exploring whether to address these expected explosions and the delays by encouraging citizens to engage in ADR, alternative dispute resolution. I know in Illinois, the court put together a task force, and one aspect of their work is looking at ways to expand and make uniform across the state court-appointed mediation. So, fueled by technology, there's 3 areas of court innovation that will be here to stay. Just as Bill and Laura said that remote delivery of legal services is here to stay, remote hearings in the court systems will most likely be here to stay. Federal courts, of course, they got a huge downstroke from the CARES Act and pretty immediately put into place video or telephone conferencing during the pandemic, and that's expected to continue. State courts across the nation embraced remote proceedings. Texas leads the country in the number of remote hearings. My data is from October of 2020, but as of then, Texas had held over 550,000 remote hearings. The court has a website and has written a best practice guide for courts in Zoom hearings, which is extremely helpful, involving telling judges what to do for pre-hearing instructions, how to handle interpreters, how are we going to handle parties and witnesses who need accommodations due to disabilities. Very thorny issues that the courts have tackled in a pretty admirable way. In Illinois here, we have remote oral arguments at the Supreme and Appellate Court levels and many circuit courts. As in most other states, the remote proceedings gradually became prevalent and most likely will continue. The benefits of online proceedings were immediately evident for the safety concerns, right? Not gathering throngs of people in our courthouse hallways and courtrooms, so we could provide court services in a safe manner. It saved time and expense, relieving parties and others from burdens like taking time off work, getting childcare, finding transportation, traveling to the courthouse, parking, etc. These gains were particularly prevalent and helpful to our low-income families and people of color who may have previously lacked access to court proceedings because they just couldn't afford to take time off work, didn't have a car, didn't think it important. But now they could more easily participate. And it's been more convenient for lawyers and members of the media who need to monitor proceedings at more than one courthouse. They don't have to spend hours driving in between. There are concerns, of course, for remote hearings. They're designed to increase access, but they also raise concerns because some people may not have access to the internet or the necessary equipment or access to knowledge and easily digestible instructions about how to use the technology. So we want to make sure that virtual courts don't create wealth-based hurdles, that those who lack access to sufficient technology get different and less meaningful access to those who have means. And of course, there's a lot of procedural concerns regarding Zoom hearings or remote hearings in the criminal field. The right to public proceedings, the right to be present, the right to confront and cross-examine witnesses, the right to effective counsel. And that is being handled in many courts by providing Zoom breakout rooms for a lawyer to consult with his or her client. I think it's pretty clear we can expect that remote hearings will continue as the courthouses are opening post-pandemic. In Illinois, our Supreme Court Chief Justice recently issued a letter to all judges across the state. We have a very large non-unified court system, but she urged that remote hearings continue even as the pandemic abates. For really interesting reports that look at lessons learned in the court system during the pandemic and what we can expect going forward, the Ohio Supreme Court and the Michigan Supreme Court just within the last month issued very extensive reports that you should check out. Both include surveys of lawyers and litigants about their satisfaction with remote hearings, and both say that remote hearings should continue. An interesting note in the Michigan report, and that's open for public comment, by the way, through August 13th. But it was noted that in Zoom hearings, minors appeared more relaxed and comfortable testifying, and they weren't as intimidated, apparently, as in the physical setting, and perhaps they're more tech savvy as well. The Michigan Supreme Court has an extremely strong recommendation, and that is that the court rules be amended to create a presumption for Zoom for non-evidentiary civil and criminal hearings, unless good cause can be shown why it should not be used. So we also have panelists here from Missouri, California, and Connecticut. I'm going to call on maybe Laura Farber first to tell us what's going on in California as they look forward with respect particularly to remote hearings.
Thank you, Jane. We have a judicial council, for lawyers from California know this, that promulgates rules that then the courts individually, various counties will promulgate for purposes of remote hearings, which is what has happened in this case. And this came as a result of the pandemic. And so now in our legislature, there are pending proposals. Our governor, Gavin Newsom, made a proposal to continue the use of technology with whatever protocols will need to be in place post-pandemic. But there's been a little bit of resistance, no shock or no surprise. Some of the unions, court reporters and language interpreters think that that's not as reliable, it's not as helpful, et cetera. So there's been some political aspects to what's going to happen to this, but most people are of the view that they predict that there will be some protocols that will then be given to the Judicial Council, whether they're going to tweak whatever they have in place now or not. And really, I see this, differently from the civil context, maybe than the criminal context, and depending on evidentiary hearings, depending on trials versus other hearings. Pre-pandemic in the civil space, we had the option of court call at the time, where you could actually call in. Most courtrooms allowed this. You could call in for hearings on motions, things of that nature. So what happened during the pandemic was we expanded to the video platform, which was changed, at least in the LA Superior Court, changed, which is my jurisdiction, changed from one technology platform to another. But folks have seemed to have embraced that greatly. And I do believe there will be some pressure exerted to make sure that there are technological improvements and access and the things that you mentioned, Jane, to make sure that people have the ability to proceed in that regard. And we have our own local moratoriums that will continue, by the way, beyond the federal one for evictions. So I think every jurisdiction is going to be handling that different, especially if it comes under state law. So that's a little bit about what's happening in California.
Thank you, Laura. Bill, what's going on in Missouri?
Good question. I would have known better 3 or 4 weeks ago, but the world's changed so rapidly. I just saw the federal court just issued an order Friday, for gosh sakes, about how they were changing some things. And they're still doing some in person, but all ADR is by video. They're doing some in person. You can still do things remotely. Very much a state in flux. In Missouri, I think in some of the rural areas, there were some courts were doing in person, some in St. Louis City or some in the county, but that's switching off bit by bit. I know John Gunn's on. He may actually have a better feel for what's happening, but I think it's kind of right now, you can't afford to go. The first thing you got to do before you go to the court is check the rules, even before you get ready, is what's going to be the rules, what's the change, because it looks like it's changing every other day almost. And like Laura says, very much of a local thing.
Yeah, that's true here as well. Amy, what about in Connecticut? Anything different to add?
We're seeing a similar thing. Appellate arguments for the Connecticut Supreme Court and the appellate court are all back in person by default, but they can request remote arguments or on an as necessary situation on a case-by-case basis. In the Superior Court, it's a bit of a mix. We resumed to our jury trials back on June 1st. But most of the hearings, pre-trials, and conferences are still being held remotely, and all the buildings, facilities of the judicial branch are now open to the public. Looking forward, I think we're going to see the same thing that Bill and Laura mentioned. I think we're going to have some capacity of having, remote proceedings, given the advantages of cost savings and also access to justice. But the real question that we're still trying to grapple with is, when will we be in that post-pandemic phase?
Yeah, we're all grappling with that, and that's one of the well-being issues. We need to build our resiliency, right? All right, well, let's move on very briefly to two other aspects that look like they might be on the horizon and stay there with respect to court operations. And the next one is online dispute resolution. As you may know, ODR is an internet-based software that allows litigants to settle their disputes or narrow issues in other larger hearing contexts. This was rolled out first in the commercial businesses, PayPal, eBay, Amazon. You probably, like me, have had disputes where you went through that process if things didn't work out the way you wanted them, and they work as well as you can expect. But it's relatively new in the court systems. Most of the programs have been launched in the last 3 or so years. There's a very interesting report from the National Center for State Courts that came out in May 2021. And you can see in that report that about half of the states, 24, have launched at least one program of ODR in the state, and most of them are piloting in certain areas and will be expanding. I know in Illinois we have one ODR platform for family matters, and many other circuits are looking at launching other ones. Generally, ODR programs are designed to increase access to justice, particularly for self-represented litigants, while decreasing the cost. They aim to do this by increasing convenience, case processing efficiency, and educating the litigants about options. So generally, litigants will try to resolve their dispute through the ODR platform first, And those who are unable to do so then will be diverted back into the traditional in-court process. It seems like more and more attention is being drawn to this being part of existing court services. And then the next slide, in terms of other help for self-represented litigants, this really expanded during the pandemic. I don't think we'll go back. I think it is clear that we're going to have a large self-represented litigant population utilizing court services. So we need to get them educated to navigate this system, which originally was designed only for lawyers and judges. So what we've seen over the pandemic is an expansion of instructions or training materials available for local courts to inform litigants and attorneys how to use remote technology. They've created electronic methods for parties to request a continuance for upcoming hearings, very simple things to do remotely. And there's been an expansion of courts using text messaging and email to provide general reminders about court appearances or alert parties about what the protocol is to enter the courthouse or the remote technology hearings. Here in Illinois, one of the judicial circuits has been text messaging for over 5 years, and the use has ramped up during the pandemic, and they're spreading, it's spreading throughout our state. So I'm going to pause here and see whether any of the panelists have anything to add about whether online dispute resolution will be embraced or any other innovative court services to help SRLs in your jurisdictions. Who would
Jane,
like
I would say in California, I'll go ahead. In California, especially in a lot of the local courts, a lot of the mediation programs have now gone at sort of the private side. The court doesn't have as many resources to, require it or to use their own folks, but when they do, more and more are embracing the online dispute resolution. And I know I've used it in my practice, and my clients love it because they're not paying for me to drive to a place. They don't have to fly to come in. And it tends to be quite efficient. Every matter I've had on online has settled, believe it or not. I mean, I was kind of skeptical in the beginning, and it worked out really well. I find that it can be extremely useful, especially when your mediator uses breakout rooms and several breakout rooms where they can pull you out to talk to counsel, or they can leave you there to talk to your clients. The clients can also feel like they can step away for a few minutes and still be okay. So I see that as the future. I don't see that changing because I don't see why it would change. That doesn't mean that won't continue to have some in-person options when things get better, if people think it's important or necessary. I just think, once again, having that flexibility is huge. And so I think that's the trend that I foresee will occur here.
Yeah, I agree. Bill, what about in Missouri?
Yeah, I mean, I think the latest I saw in the federal court was still saying do ADR on online. There are days when I think that's great, and there are days when, hey, I want to have in person. But I think that's the kind of it's all an adjustment to new normal. We all got to adjust to something different than we've had. And as Laura's experience, hey, it's worked. Okay, when it works, that's great, and that makes a difference. So it'll be interesting. I think the remote hearings, though, I think is really useful. In rural Missouri, so often lawyers are covering 4 or 5 counties and are driving from hearing to hearing. I think the remote hearings really is a cost savings and a real economical thing, both for lawyers' time, well-being, but also for clients.
Yeah. All right, I'm going to turn to Amy to talk about the Bar Association. But before that, Amy, do you have any comments about ODR and other SRL assistance in Connecticut from the court's perspective?
Similar to what Bill and Laura said, we are seeing that mediations are going back in person, but we're hopeful that given the benefits and cost savings and access for ODR, we'll see that post-pandemic as well.
Great. All right, Amy, sorry, I'm introducing you after you've already spoken several times, but we had to be fluid. I have to be flexible. Thank you for helping fill in for the justice here. So we're going to turn to Amy Lynn Meyerson now. She's the solo practitioner of the law office of Amy Lynn Meyerson, and she practices in the area of domestic corporate law, concentrating in formation and growth of emerging businesses and nonprofits, computer law, and venture capital. She's a member of the ABA's Board of Governors, a past president of the National Asian Pacific American Bar Association, NAPABA, and the NAPABA Law Foundation. She's a past chair of the ABA's solo and small firm and general practice divisions. Ms. Meyerson is the founder of the Connecticut Asian Pacific American Bar Association. And Amy, I turn it over to you.
Thanks, Jane, for that kind introduction. I'm honored to have served as the first Asian American and the 97th president of the Connecticut Bar Association. We accomplished a lot together towards advancing the CBA's mission of promoting justice and strengthening our profession. It has certainly been a year of unprecedented challenges. The ongoing COVID-19 pandemic, great social unrest sparked by the death of George Floyd, threats to our democracy at the US Capitol, and overt hate crimes against Asian Americans, to name a few. The CBA met these challenges through perseverance and innovation. And with our safety and health and overall well-being in mind, we adapted, shaped a better legal landscape, and made the community great strides to serve our members and our community. One question that's kept us up many nights is what more can the CBA do to assist our members and our communities during the lockdown and once we emerge from this pandemic? I'm pleased to report that the CBA members embraced technology, re-examined the status quo, and collaborated to find creative solutions today. Today, we are stronger, more connected, and more inclusive than ever. We focused our energies in many of the areas that Laura and Bill highlighted and worked closely with the judiciary to implement several of the solutions that we just discussed that Jane also presented. Here are some of the things we did. We were one of the first bar associations to speak out against troubling current events to demonstrate the CBA's unwavering commitment to protecting the rule of law, democracy, and our justice system. On January 6, 2021, the CBA issued a statement condemning the storming of the US Capitol and the attempts to disrupt democracy. And after the Atlanta spa shootings on March 18, 2021, we denounced acts of violence and against Asian Americans and called for solidarity to support the victims and prevent future incidences. To ensure our right to vote in federal and state elections, our members volunteered at polling places across Connecticut. We also joined the ABA in promoting its Poll Workers ESK initiative, encouraging legal professionals to volunteer at the polls in November 2020. And leading up to the election, our CBA Young Lawyers section conducted a creative and successful voter registration drive. Joining together with the ABA and other bar associations on 7th, 2021, the CBA hosted the statewide Law Day celebration with the national theme, Advancing the Rule of Law Now, to reflect on the role of law in our society and to help encourage a deeper understanding of the legal profession. The CBA hosted our 4th Rule of Law conference on June 28th, focusing on the integrity of the American election system. Working to further strengthen the rule of law and access to justice, the CBA also pursued a very active legislative agenda, advocating for several rule changes, including 3 practice book rule amendments. The first, the addition of Rule 8.47 that makes it professional misconduct for an attorney to engage in discrimination or harassment in the practice of law. Getting this rule adopted was a Herculean effort by a working group led by CBA President Cecil Thomas. Cecil took the lead on our diversity, equity, inclusion, and access to justice initiatives this past bar year. You'll hear more from Cecil about how we were able to build consensus and handle setbacks as we advance this rule at tomorrow's Workshop B on leading a bar in polarized times at 1:25 p.m. Central. The second new rule is an amendment to Rule 5.5 that permits non-practicing or retired out-of-state licensed attorneys to engage in supervised pro bono services through a legal aid organization, law school, or bar association program. This rule increases the pool of volunteer attorneys to assist in the increasing number of our most vulnerable neighbors who need access to domestic human necessities. And the third new rule is Rule 1.8E that allows a lawyer representing a client pro bono to provide modest gifts to the client to pay for basic living expenses, such as a bus fare to get to court. The CBA was also pleased to support a Connecticut House Bill 6531, establishing the right to counsel in eviction proceedings in Connecticut, which Governor Lamont signed into law on June 10th, 2021. Fortunately for Connecticut, Cecil Thomas, who's our CBA president now, is a housing attorney with Greater Hartford Legal Aid and is tackling the looming eviction crisis head on. A recent census data reports that over 6 million people in the US are currently behind on rent. Diversity, equity, inclusion remained a top priority for the CBA during this unprecedented challenges. We added a new recurring DE&I column in the Connecticut Lawyer magazine that keeps us updated on diversity, equity, and inclusion in the Connecticut legal community. Some of our programs this past bar year included the Constance Baker Motley Speaker Series on racial inequality that we co-hosted with the Connecticut Bar Foundation. We also continued to promote the Connecticut Legal Community's Diversity and Inclusion Pledge and Plan. And we also have a Diversity Presidential Fellows Program that gives fellows opportunities to become involved in the substantive work of CBA sections and to develop into future leaders, and serves to promote the CBA sections and committees to other members of the CBA Young Lawyer section and the bar. We made it easy for people to find ways to give back during the pandemic. The CBA Gives campaign that we launched on Giving Tuesday in 2020 encourages members to donate time or money to legal and social service programs that align with our mission of advancing the legal profession and principles of law and justice, or meet the needs of Connecticut's most vulnerable residents. The opportunities include Project Feed Connecticut, the DMIOLA Fund that supports our DE&I programs, CBA Pro Bono Connect that trains and links volunteer attorneys with pro bono clients, CBA Lawyers in Libraries, CBA Virtual Pro Bono Legal Clinics, and Connecticut Free Legal Answers. The Connecticut Bar Association continued our proud reputation of providing high professional development and networking opportunities, crucial to equip CBA members with the ideas, information, and resources to serve our clients while staying connected, resilient, and motivated. This past bar year, using virtual platforms, our speaker offered valuable and relevant content in over 280 continuing legal education programs, including the 2020 and 2021 Connecticut Legal Conferences, the Constance Baker Motley Speaker Series on racial inequality, the Bankruptcy Series, the Federal Tax Institute of New England, the Young Lawyers Series, Constitution Day and Law Day presentations by our Civics Education Committee, and other CLE presentations during meetings of our 70+ sections, committees, and task forces. To better serve our members, we adopted and are implementing the current 3-year Connecticut Strategic Plan and advanced members' benefits in these innovative areas. First, the CBA In-House Counsel Committee provides cost-effective, high-quality, relevant content and resources for general counsel and other in-house attorneys. Second, the CBA Sell and Small Firm Resource Center focuses on starting a practice, growing a practice, and leaving a practice. And third, the new Experienced Lawyers Committee leverages skill sets, accumulated knowledge, and judgment of experienced lawyers to promote the public interest and the legal profession. We also hosted the first ever in history and possibly the only virtual swearing-in ceremony with the U.S. Court of Appeals for the Armed Forces with Chief Judge Stuckey zooming from the basement of the CAF courthouse. To create students from law school to college, from high school to college, law school to law practice, the CBA offers budding lawyers programs like Pathways to Legal Careers, CBA Future the Legal Profession Scholars, Law Camp, and Civics First mock trial competitions. Additionally, we joined the judicial branch to congratulate candidates who passed the Connecticut bar exams administered in February and October of 2020, and to welcome new attorneys admitted to the Connecticut bar in June 2021. Our judges are the backbone of an independent, fair, effective, and efficient judicial system. It was therefore our privilege to testify before the Connecticut Judicial Compensation Commission in support of fair and appropriate judicial compensation to enable the state to attract and retain qualified, experienced, and diverse lawyers from every segment of the legal profession to a career in judicial service. For over a year, we have experienced life as shut-ins, still not knowing exactly when we'll be able to move about freely without having to consider COVID-19 safety protocols. Let's take our time to ease back in as we establish new routines in the new normal. Our Lawyer Wellbeing Committee has cared for our emotional and mental well health, sharing insights and tips and CLE programs in the Wellbeing feature in the CBA docket, articles in the Connecticut Lawyer, Wellbeing Challenges, and the Wellbeing Pledge campaign that seeks commitment from legal employers to promote lawyer well-being and healthy work environments. While the legal community has gradually been tuning into the value of promoting lawyer well-being, the pandemic and a multitude of other stressors arising since March 2020 have accelerated this recognition by necessity. In addition to our outstanding CBA staff and leadership team, we are truly fortunate to have so many good and special people in our CBA membership and throughout our legal community who are dedicated and committed to the association's causes and the vitality and health of the legal profession and our communities. Cecil Thomas is doing a fantastic job leading the Connecticut Bar Association, and I look forward to continuing to support the CBA as its immediate past president and in my new role as a member of the ABA Board of Governors beginning on August 10th, and as co-chair of Governor Lamont's Hate Crimes Advisory Council. Stay safe and be well. Thank you.
Thank you very much, Amy. I appreciate that. I just have a question, kind of drawing on all those accomplishments of the Connecticut Bar Association and Bill's comments about listening. How do you go about determining, there's so much need out there, but how do you go about as a bar leader determining and prioritizing the needs of your members? There's only so much time in a day, so only so many resources you have. How did you do it? And how
Yeah,
do you
well, we're
recommend
still
they do
working
it?
on it. So I think it's a challenge that all bar associations have. We put things out by email, we put them on our website, we put them on our social media, but we always, we'll get a question from a member saying, oh, I didn't know about that, because people aren't really reading things. So we did a couple of things in addition. We put a comments box on the very front page of our website where people can put any thoughts they want in there, and we will respond to them quickly. We also started pushing the judicial branch's social media out on the front page of our website. And we continue to try to connect with members individually and also the general public when we have our pro bono clinics and other types of community involvement to try to get people to let us know what it is that they need. And certainly after we make statements, we do often get a lot of commentary that we've been able to address as well.
Okay, well, thank you all, Laura, Bill, and Amy, and especially thank you for helping me pinch hit for Justice Nelson. This concludes our session today. I hope you found it useful. You can return to the main stage now by clicking on the blue Leave button and heading back to the platform and the main stage.